What's needed to bring a probate proceeding in Florida? I decided to do this video because on numerous occasions we get calls from people who are interested in pursuing a probate in Florida. It could be a formal probate or it could be a summary probate. Formal probates take longer and it's used most often when assets are valued at greater than $75,000. So these are assets that are subject to creditor claims. So it would exclude things like the homestead or up to 2 vehicles, $20,000 in household items and furnishings. So when bank accounts, money markets, additional real property that's not homestead, when all of that is greater than $75,000 and the decedent passed away less than 2 years ago, then you have to bring a formal probate. Summary probates can be utilized if the decedent passed away at least 2 years and a day, so more than 2 years ago. And if the assets, once you take out homestead, $20,000 in household items and 2 vehicles, so once you take out anything that's exempt, if the assets are $75,000 or less, then you could bring a summary even if the decedent didn't pass away more than 2 years ago. However, you always should consult with an attorney because there's other considerations, times where a formal has to be brought regardless of those requirements, and I have that in another video that you can watch if you want. But the main reason I wanted to do this video was to clarify some things, because we get calls all the time from people who are looking to bring a probate action, but they don't have all the documents that are needed in order to do so. So some examples of what you need in order to bring a probate. First and foremost, and this actually happened today on a call, we need proof that the person who passed away actually passed away. This is usually done through a death certificate, or sometimes if they passed away in another country, there is another document that's provided similar to a death certificate, but there needs to be some kind of legal proof that the person did pass away. Without this, without a death certificate, which is most common, then we can't actually bring a probate action. It's required to file a death certificate. Or again, if the person was a Florida resident, but they passed away in another country, there should be a comparable document that country can issue that verifies that, yes, this person actually is dead, so that the court knows, okay, now we can make sure their assets go to either their heirs, people who have rights to them under the law, or to beneficiaries if they had a will naming specific people who gets their assets. Which brings me to the next thing that is required for probate. If there is a last will and testament, it is very helpful if you have the original last will and testament, because typically it is the original that needs to be recorded with the court whenever possible. Other things to know about a last will and testament is it is a requirement in the state of Florida that it is signed after the testator, the person who created the will, by 2 witnesses who were in the presence of the testator. They had to all be in each other's presence when they signed. This is a legal requirement, even for a handwritten will. So somebody can write their own will if they want, and this happens often. But it does have to be signed by them at the end and 2 witnesses who all signed in each other's presence for it to be valid. So if there's not witness signatures on the will, it's not going to be valid. Another thing that is very helpful with a last will and testament is something called a self-proving affidavit. This is a document that is signed by a notary. The notary is actually signing, saying, yes, this will was signed in front of me and the witness is signed in front of me. The nice thing about the self-proving affidavit is it makes it so that the will can be accepted as is. Again, this is if it's an original will, meaning we're going to accept it as is with the signatures of the witnesses. If you don't have this affidavit, doesn't mean that the will is invalid or it won't be accepted, but it often does require extra steps. So as an example, the witnesses, you might have to track them down and they'll have to sign an affidavit affirming that this is actually the last will and testament that they witnessed and it was the person person's last will and testament. Sometimes you even have to get testimony and do a hearing with regard to this. Oftentimes too, that could be the requirement when you only have a copy of a will. There's extra steps that have to be taken. So that's something to keep in mind. It's really important to try to locate the original will if you can find the original will. The other thing that is definitely needed, at least to an extent, is a certain idea of the assets involved. One, so we can determine what type of probate is needed. As I said earlier, if the value of the assets are over a certain amount, it's going to require a formal. If we don't know the value of the assets, we just know the person, the decedent, the person who passed away owned a bunch of accounts, then most likely we'll have to do a formal, because if we don't know the value of those accounts, there's no way to know for certain if we would qualify for a summary if the decedent passed away within the 2 years. It hasn't been longer than 2 years since they passed away. So it's super, super helpful to have actual account information, or to gather as much information as you can about accounts, because that could definitely change things. It's also very helpful if you could gather information about any debts the decedent may have owed, because these are things that do need to be taken care of during the probate process when there is property subject to creditor claims. Exception for this, and I see this all the time, if somebody is going to probate just a homestead property, nothing else, and this does happen all the time, creditors can't make claims against the homestead property. It's still good to have the information because we want to know about creditors who might be wanting to make a claim, but in the case where there's just homestead property or homestead property in a vehicle, creditors aren't going to be able to get paid out of those particular assets. And this often includes attorneys as well. Any type of creditor isn't going to be able to get paid from the homestead property itself or up to 2 vehicles that the decedent owned upon their passing. Another big one that I see all the time that can stall things and even sometimes prevent a probate from being brought, and this happens especially when you wait a very long time to bring a probate, is who are the decedent's heirs. So in an instance when we don't have a last will and testament, so whoever is inheriting the property is who, or the assets is who the law says they go to. Sometimes it could be lots of people depending on the family tree. Also depending on who may have died before or after the decedent. This all changes things when probate's concerned, and sometimes it even does mean additional probates are required if someone passed away after the decedent, because the property technically passed to that person. So now it has to be probated through their estate. So oftentimes people think, oh, nobody else is interested, or I was the closest relative, or nobody else talked to him, or nobody else talked to her. Doesn't matter. If you don't have a will, an heir is an heir, and we have to know the names and how to get a hold of the addresses for any possible heir. When we get complicated family trees and lots of people who under law can inherit, sometimes it actually requires what's called an heir search before we can proceed, because we cannot leave heirs out. I see this far too often when people just assume, oh, he already told me he doesn't want anything to do with the estate, or he hasn't talked to my uncle or my aunt in years, so of course he doesn't want to be involved. They have to be involved. They have to be named. So keep that in mind, that you do have to disclose your relationship to the decedent. If you're a child, you have to either be a biological child or legally adopted, and you have to also make sure you list anyone else that's an heir, including stepchildren who were adopted. And sometimes, like I said, when it gets very complicated and years have passed, and we're actually to the point where aunts and uncles or nieces and nephews, or even grandchildren, great nieces and nephews are going to inherit, we have to have the names of everyone, and it can get very, very long and complicated. The attorney is there to help, but you may need to do that heir search. Okay, so I hope this is helpful with some of the documentation that is required in order to be able to bring the proper probate. And if you have any other questions about probate and you're in Florida, don't hesitate to reach out to our office. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.